Ladies and gentlemen, for the welcoming address to the participants in the second St. Petersburg International Legal Forum, we invite here to the podium the chairman of the organizing committee of the forum and the acting Minister of Justice of the Russian Federation, Mr. Alexander Konovalov. Ladies and gentlemen, on behalf of the organizing committee of the second St. Petersburg International Legal Forum, I'm happy to welcome you here at the opening session of the opening plenary session of the forum. The forum is taking place not only in the very heart of the city and in its most famous landscape, but inside it, which is symbolical because it proves that St. Petersburg and Russia are ready to offer the best what they have in terms of architecture, art, creative heritage, philosophical and intellectual thinking, and also legal thinking to provide comfortable conditions for the participants and guests of the annual legal forum. However, legal protection may be complicated in terms of its various categories of protection. The core of law has been constant for many centuries, and the very idea is to prevent evil and arbitrary decisions in all the ramifications, and to provide safe and secure conditions for the individual, for the law-abiding initiatives to protect their property and intellectual rights. Lawyers, as the conductors of this idea, indeed translate this idea to the public, and it is our work that is the benchmark of the legal profession in the modern world. The qualified, honest, and understandable lawmaking and law enforcement are the best vehicle of propaganda for law. We would be happy to see if the discussions in this forum would help the participants to solve the tasks. Russia is changing rapidly today together with the global world. The idea of the viability of law and its enforcement and its compliance with the realities of the specific place in today's world is becoming even more topical. The world is global today, and society and the markets are changing every day. And this means that to become successful, lawyers need to be to the best of their abilities and to the best of their abilities in terms of time and effort to adjust their thinking about motivations and preferences that rule the groups of people across the world. And on the opposite, any unprompt reaction to such changes may cause cataclysms. That is why we think that the crowdsourcing technologies in terms of the open government is becoming more popular. The monitoring on the behalf of the public is becoming more important, involving but all social groups and the legislations and practices, guarantees and trust of laws of various legal systems and countries and our societies to laws is becoming even more topical. The second International Legal Forum has twice as many people participating in it as last year. We try to organize platforms for discussions. We have about 40 roundtables planned for tomorrow. But we really do not want to ignore some conceptual issues that we would like to discuss today during the plenary session. In the future, we really want to see the forum not only as a popular and hospitable annual event, but also as a permanent online mechanism to discuss the most topical and most interesting and key issues and problems of law enforcement, including for law professionals, preparation to discuss such challenges on a global level and also professionally. Ladies and gentlemen, I welcome you here to the St. Petersburg International Legal Forum, and I wish you all success in your proceedings. Thank you very much. Ladies and gentlemen, we would like to invite here to the podium the moderator of the plenary session, the director of the State Hermitage Museum, Mikhail Piotrovsky, and participants of the plenary session of the Second St. Petersburg International Legal Forum. Her Excellency, Madam Uain, Minister of Justice of the People's Republic of China. Mr. Eric Bergsten, former Secretary of the United Nations Commission on International Trade Law from 85 to 91, Chairman of the Legal Mood, named after William S. Wissam. His Excellency, Mr. Eric Holder, Attorney General and Minister of Justice of the United States of America. Anton Ivanov, Chairman of the Supreme Commercial Court of the Russian Federation. Mr. Jean-Paul Decour, President of the International Union of Notaries. His Excellency, Mr. Kenneth Clark, Lord Chancellor and Secretary of State for Justice of Great Britain and Northern Ireland. His Excellency, Mr. Vincent Lamanda, President of the Court of Cassation of the French Republic. Chairman of the Government of the Russian Federation, Dmitry Medvedev.
Good afternoon, esteemed colleagues. Good afternoon, ladies and gentlemen. I welcome you at the second St. Petersburg International Legal Forum. The venue for this forum was selected. It was a very unique venue. I searched my memory and I haven't thought of anything of anything at this kind in the Dvortsovaya Square. St. Petersburg is the city of lawyers. Last year, I also participated in the first forum, and as ministry and together with the Minister of Justice, I'm glad to see that its number of its participants grew threefold. Now I can see here the leading lawyers from more than 50 countries, my colleagues that had the courts, ministers of justice from leading states of the world, and the heads of very powerful international organizations. And I'm very glad to see you here, to see you participating in this forum, and I would like to thank you for that. And I would also like to say that addressing the lawyers always invokes particular feelings with me. I clearly understand that we have here not only my colleagues, but the representatives of different legal systems, the followers of different legal theories and doctrines. But we all are united with the common system of coordinates, which is based on the recognition of law as a supreme value. As a supreme value, I emphasize that. From being students, we understand that only using such universal mechanism as the rule of law, we can provide justice, equality, and freedom. We can protect the rights of the people, the sovereignty of the states, and create a humane international rule of law. The plenary meeting of the forum is dedicated to new challenges to the law in the globalized world. Today, each state faces the problem of adaptation to the changing world. Our country also knows this problem very well. It doesn't mean that we know answers to all questions. We are also trying to seek our answers. Sometimes we fail, but we are trying to do that, and we will continue to do that. Last 2 decades in the Russian Federation, we have seen the unprecedented transformation of the legal system, and when we are criticized, sometimes justly, sometimes unjustly, people probably forget that our legal system, our legal framework, despite of its deep roots, despite of the fact that we are a part of Europe-wide legal family, our legal system is quite modern, quite young, but nevertheless it is developing, and probably this is the prerequisite for its future success. The mechanism that provides the protection of fundamental rights and freedoms, the equality towards law, the striking balance of state and private interests, we are only creating such a mechanism. Today, we, as any developing but democratic state, any bill that deals with the interests of the people and has a very basic importance for the people, is widely discussed. The development of internet and IT provides any person with the possibility to participate in the preparation of the text of the document. He can not only leave its comment on the site, but he can only propose his own wording of the rule, which can potentially become the rule of the law. And we have already discussed some such bills, like the law on police. It was widely discussed by thousands of people, and we will continue this practice. A series of states has such fashionable crowdsourcing technologies in preparation of the mostly important laws. more than 100 years ago, one person said that the great cause of the legislation is in creating the public good from the largest number of private interests. I think this is a very good wording, which didn't lose its brilliance for the last years. The involvement of public allows to make the law of high quality and avoid corruption-prone rules justified by the interests of narrow economic and political groups. Besides, we can also increase the openness and the legitimacy of the legislation, because each participant of the discussion feels that he is a part of the preparation of the law, and in future he will be readily enforcing this law and abiding by it. Such is the nature of the people, of the human being. The open legal policy is a prerequisite for the system of the open governments. You know that the International Partnership Open Government includes several countries, and it aims at making the state governance process as transparent and as high quality as it can be, due to the proactive involvement of the civil society and use of new technologies. And I am the strong supporter of this idea. In April this year, I tabled a draft of the law on changes in the civil code of the Russian Federation. This law presents the considerable modernization of the main provisions of the civil law. It was prepared for more than 4 years. It was widely discussed in official and in unofficial fora, in internet, at many conferences and round tables. Prior to being submitted to the State Duma, this law received hundreds and thousands of remarks and suggestions from the public institutions, business community, scientists, and ordinary citizens which want to participate in creating laws. Sometimes I felt that the controversies and the differences of the participants of these discussions are mutually excluding, but eventually we could create a common text, a common wording. This is the victory of legal thinking, and we could adopt it in the first reading. This system should involve the working infrastructure of accumulating public initiatives in making law, and the biggest flow of information should be processed in time and with high quality, and it should be transformed in suggestions wrapped in legal form. We have also provided the predictability and systemic character of the legislation changes and their compliance with economic and social policy and contemporary challenges and threats. In order to do that, we should create modern scientific and methodical centers which would provide the constant constructive dialogue between the law drafters, public, and law enforcers. In many countries, such centers are already established on the base of leading research institutions and law schools. But it is also possible to begin such work with a scratch. I believe that the modern society faces the greatest task to formulate and to offer to the society non-controversial and efficient system of rules which will be able to solve tasks not only of today but of tomorrow as well. It is very important today, given the demand from the civil society formed for the last years in the world. This demand requires the high-quality, efficient, and maximally open authorities. This demand exists not only in Russia, but in other countries in the world, in the Western Hemisphere, Eastern Hemisphere, in the North, in the South. This is the reality that we all have to count on, and the authority and the state power should respond effectively to this demand. Esteemed colleagues, I am completely agree I completely agree that the open legislation should not be only open to the citizens of the country, but should be open to the outside. It should take into account the best practices of foreign legislation, comply with the international law, and be competitive. The lawyers always are watching attentively what is happening in the legal system of their neighbors. And each developed state tries to protect their national interests through the legislation and to provide the competitiveness in the world. The idea of the law competitiveness could be considered in two aspects. One of them, the internal one, is related to the competition of national law with the foreign one as a regulator of the relations on its territory, and the external aspect reflects the competitiveness of the law with other systems of regulations, the external ones, but the law which is not efficient and which is unpopular in its country cannot be competitive on the external level. And we know some states that have such inefficient systems. And such law cannot be competitive on the wider area. The external competitiveness of the law is also related to the factors of economics, politics, and cultural nature. For example, the modern financial centers in the globalized world prescribe to all actors, irrespective of their nationality, to abide by the set rules of game. Another factor is the activities of the operators of the market of the legal services, which are the conductors of the respective legal system. And we also know that each phenomenon has its other side, and there is also the bad competitiveness of the law, and some countries, some systems impose their own systems on their neighbors and trying to push through their own political decisions through the legal systems of other countries. This is the reality of our modern life, and all attending lawyers here know that, and probably it will be discussed today. As we know, the best law is the good balance between private and state interests. This is a compromise between different perspectives. And you can find the compromise only when you want to hear each other, when people want to hear each other, when they want to understand the standing of those who participate in discussion with. I am convinced that we, lawyers, are those people who can and who want to secure such a mutual understanding. We studied that in the universities, and it is very important both for our states and for the international rule of law. I would like to also stress that combating the global challenges of our age, such as the proliferation of the weapons of mass destruction, international terrorism, organized transnational crime, narcotic drugs trafficking, and natural and man-made disasters, such challenges can be combated only by joint efforts of the states on the basis of strict abiding by the rule of law. It is frequently said that the international system of law is obsolete, and its rules cannot effectively combat new threats. Partially it's true, because everything is becoming obsolete and the legal form is also becoming obsolete. But the essential need of modernization of the international law does not exclude its basics. And I believe that the most dangerous actions are the unilateral ones that contradict the fundamental principles of the Charter of the United Nations as a main forum where the international community solves its issues. We do not have another forum. We just do not have it, even if somebody doesn't like it. And we understand that it is the UN Charter prescribes the respect to the rule of law and sovereignty of the states. And one more remark that I deem very important, given my political experience, my political practice. This is the doctrine of state sovereignty. It should not be watered, even if it is good for achieving some political goals, including very dangerous goals. It is very dangerous for the international rule of law. And there are a lot of threats to the doctrine of international law for the last decades. Let's remember the military interventions against other states, circumventing the United Nations, and also the declarations that some political regime lost legitimacy. That declarations were made by the states, but not by the people of their respective country. Imposition of different sanctions, circumventing the international institutions. This all doesn't help to improve the situation in the world. And the consequences of the military operations in other country also always leads to the same situation. The radicals come into power. Not to mention that such actions that undermine state sovereignty can result in a full-fledged regional war. And I don't want to scare anybody, but it can also lead to the deployment of nuclear weapons. And we should take it into account when we analyze the problem of state sovereignty. That is why all the nations have equal responsibility to provide common security. And when the international decisions are taken, the opinions of all parties should be taken into account, as well as the religious and historical and cultural peculiarities of the countries. All the attempts to impose one's own opinion do not help to establish a rule of law in the long term. For the last years, Russia proposed a series of initiatives aimed at enhancing law mechanisms in different areas. It is the task of strengthening the legal foundation of intergovernment relations is the basis of the initiative on signing the Treaty on European Security. We also propose the ideas for international mechanism of preventing and relieving the disasters on the sea shelf, the combating sea piracy. We also proposed the idea of creating a global framework of energy security. We also proposed a concept on protecting the copyrights in the internet. This area is out of the reach of the legal regulation. Here we can see a lot of problems, and we can see what should not be done in internet, but we should work on that and not avoid that. It is very soon that in Camp David, in the G8 meeting, we will discuss a lot of these relevant problems, including energy and food security. And of course, we will discuss a lot of international issues, such as the situation around Syria, nuclear security issues, and other problems. I am fully convinced that the right of the people to select their own development path is the same value as those ideals that we are all committed to, the ideals of freedom and justice, the ideals that we are going forward to achieve. Dear friends, I wish all the success to our conference. Thank you.
Well, before we proceed to discuss the key topic of this forum, the legal policy in the 21st century, new challenges for law in a global context, and the ideas that were pronounced by Dmitry Medvedev. Let me take a few minutes to say a few words. First of all, I should say that we are in a very unique place in the very heart of the city, right in the Palace Square, and this is very appropriate that such an event is taking place in the main square of St. Petersburg. Indeed, on the other side, there is a Winter Palace, which has for many years served as the seat of the Russian emperors, and in this building of the General Staff, besides the War Ministry, before the 1917 revolution, the Ministry of Foreign Affairs and the Ministry of Finance were housed. And now we have a museum here, and members of the participants in this forum will be one of the first visitors to the newly refurbished premises of the East Wing of the General Staff building. And very soon we'll display here exhibits of the State Hermitage. And it is very important for us to be involved in this forum as the full-fledged participants. Tomorrow we are going to discuss very important issues of legal culture and anything connected to the legal culture and the law enforcement. We talk a lot about it, and we hope that this forum would provide another impetus to this discussion. And importantly, among the speakers of this plenary session, we have representatives of various legal professions, ministers of justice, judges, professor of law, notary public. Also, we would hear presentations from the representatives of the common law system, of the European continental law, and also of the legal system of the People's Republic of China, and of course of the Russian law. And I think it would be a very interesting and fruitful and informative procedure. So, however, has questions or comments on the presentations, please raise your hands. But first, I'd like to give the floor to Madam Wain, Minister for Justice of the People's Republic of China. China is a country with a unique legal system, a system which has been developing for thousands of years and reflecting the traditions of the Chinese people, and which has always been in sync with time. Today, China is a country with two legal systems, and probably Madam Wain will talk more about the most recent tendencies in the legal development of China. Thank you.
尊敬的各位女士们、先生们、朋友们，很高兴有机会来到俄罗斯。
I'm happy to have the opportunity to speak in this northern capital of Russia and to take part in the second St. Petersburg International Legal Forum. First of all, on behalf of the Chinese delegation, I would like to express my sincere gratitude to the organizers of this forum for the successful and wonderful organization of this forum and for the efforts of the Russian government to organize this forum. Today's world is in a very complex process of transformation. The world is multipolar, and the global economy is developing. The effects of the global economic crisis are not over, is still felt, and we're talking also about energy security, food security, and climate changes. And in this context, law is one of the most important instruments to stimulate economic growth and provision of harmony and stability in society. The main theme of this forum is legal policies in the 21st century, the new challenges in a global world. And I think that this is a topic which is of paramount importance to push intergovernmental cooperation. The establishment of a law-based society is an important element of the development of human civilization. The government of China, in parallel with its efforts to accelerate economic growth, pays a lot of attention to the establishment of a law-based society. The key priority here would be to establish a legal system which also looks at some Chinese specifics and uniqueness. Through constant effort, we managed to achieve a lot of success in developing a law-based society. The main prerequisite of a law-based society is comprehensiveness of laws and of the legal framework. By the end of 2010, we adopted 236 legal acts and 693 regulatory acts and 2,600 local legislative proposals. All these legal texts reflect the main areas of law, and we may claim that we already have some kind of a comprehensive legal framework for our development, for our economic, cultural, and political development, and for the protection of the environment. The key priority is law-based governance. For many years, China has been making a push in this direction. In the end of 2004, we published a program, a national program, to strengthen a law-based governance. And in October 2010, we adopted recommendations on the strengthening of the law-based governance of state ministries, where we actually define quite clearly the requirements and for the civil servants at different levels in terms of establishing an open government, in terms of improving the legal knowledge and culture. We managed to achieve, to raise the legal culture of civil servants, of government officials at different levels, and we managed to achieve, to make a good success in various areas based on law. The court system, fair and authoritative court system, has been improved significantly. In the recent years, we are conducting some court reforms and legal reforms, and with the purpose of improving our performance, with the purpose of containing the and balancing the powers of the various branches of power. Through our reform, we managed to make a breakthrough in developing our court procedural reforms, our investigative capacity, and conducting a court policy based on the strict compliance with law and fairness. We are building a system of public corrections and providing assistance to the victims of various criminal abuses. The court system is part of the Chinese specific legal system, and its reform is important for the provision of rights and interests of the common folk, and for the establishment of a democratic law and order system. We are trying to raise the legal culture of our population in a country where we have 1.3 billion people living, and in a country with thousands of years of history. Law-based governance systems is not a simple task. And the task of the Chinese government is to pay attention to improve the legal culture among the population and also develop a legal system with Chinese specifics.
Starting from 1985, the Chinese government has implemented five-year plans pertaining to the dissemination of legal knowledge amongst the population. Currently, we are implementing a sixth five-year plan. Through the 20 years' efforts and huge inputs, we have achieved considerable improvement of the legal culture amongst ordinary citizens. Ladies and gentlemen, the setting up of a society governed by the rule of law is very important. In China, we take into account the peculiarities of our country, and we also take into account the necessity to capitalize on foreign experience. Thus, based on our tradition, we also master the best practices of foreign countries, thus achieving the unique path of the society governed by the rule of law with Chinese peculiarities. We are paying great attention to foreign interaction and cooperation. We participate in foreign countries with regard to international treaties and agreements. We signed cooperation agreements with many countries. We have 110 agreements with 65 countries that envisage cooperation in the legal sphere. We are also participating in more than 20 conventions that provide for legal cooperation. So we cooperate with all the countries, regions, and the most important international organizations. Our world requires stability and a society governed by the rule of law. The setting up of a harmonized legal system is an integral part of our world. It is our common understanding. We are absolutely sure that the St. Petersburg Legal Forum has been contributing to ideas exchange of different legal cultures. The Chinese party has been very positive about the participation and has been contributing to the participation in this event. We think that it is necessary to increase mutual understanding, and we hope to contribute to the development of the global legal culture. In the end, I would like to wish success to the forum and all its participants. Thank you. Thank you very much, Lady Minister. Now I would like to grant the floor to Mr. Eric Bergsten. 16 years of working in different UN organizations, 6 years of the head of the UN Commission on International Trade Law that initiated a lot of documents in the sphere of international trade law, and these commissions, and he personally contributed a lot to the harmonization of legal systems. Recently, he has also been performing a very important function. He is the head of the William Viss International Commercial Arbitration Moot. Next year, it will take place in Vienna. It is 20th time, and it is a traditional event that involves a lot of students from all over the world. So the floor is yours, Mr. Bergsten.
Thank you, and I thank the organizers for inviting me to speak in this event. The economic globalization of the past half-century has led to increased efforts for the unification or harmonization of the law in a large number of areas. These efforts go on in a number of fora, both intergovernmental and non-governmental. There's been much progress, but progress is slow. And I would like to discuss briefly 4 obstacles to progress in the area. My experience is mostly in the private law area rather than in the public law area, and certainly not public international law. There are the obstacles in the private law area tend to be more technical, doctrinal, than national interest, which is an obvious obstacle in the more political, sensitive areas of regulatory law. Nevertheless, my first example relates more to regulatory law than to private law, but it is an illustration of one of the obstacles to the unification of law, and that is general cultural expectations. And specifically, I'm going to pick up the expectation in regard to personal privacy. Now, different societies have different levels of concern about privacy. In the United States, where I come from, there's a much lower concern for personal privacy than there is in Western Europe, and particularly in Austria, where I currently live. It would not be strange for 2 strangers, Americans, who meet in an airport lounge waiting for connecting flights to share details of their private life that would be completely unthinkable in Austria or generally in Western Europe. I don't pretend to know where this cultural difference comes from. I suspect that one element is that the United States is a country of immigration with a very high level of mobility within the country. We are used to meeting newcomers or strangers and getting to know them quickly. I suspect that the concern for privacy in Western Europe was reinforced by the experiences of the dictatorial regimes of the mid-century, mid-20th century. These differences towards privacy have manifested themselves in many ways. One of them has been the difficult negotiations between the United States and the European Union over the sharing of data about passengers traveling by air to the United States. Now, this can be seen as an example of difference in national interest because the United States sees itself as a target for terrorism more than is the attitude in Western Europe. Nevertheless, it also reflects a difference in the general cultural expectations of the population. Now, my second obstacle is just the level of doctrine. Remember, we're talking private law. There's no subject more central to private law than the law of contracts, law of obligations, but specifically of contracts. Although a contract tends to be a contract anywhere in the world, the doctrinal basis for the obligations in a contract are quite different. The major divide that affects international commerce is between the common law and the civil law, though there are certainly differences within these 2 large families of law. The first attempt to unify an important area of the law of contracts was undertaken by UNIDROIT, starting around 1930, where they drafted what became the Uniform Law on the international sale of goods, generally known as ULIS, and the Uniform Law for the Formation of Contracts for the International Sale of Goods, both of which were adopted by diplomatic conference in 1964. No fault of UNITLAW that the text could not be generally accepted. The common law countries had not participated in the exercise. The United Kingdom was a member of UNITLAW, but the record shows that it did not participate actively in the process. The United States became a member of UNITLAW immediately before the diplomatic conference, but as to be expected, its influence on the final text was minimal. It was not only the civil law, common law divide that led to the general rejection of it, of the adoption of those two texts. But one of the first tasks of the United Nations Commission on International Trade Law, generally known as UNCITRAL, and I'll use that abbreviation several times during my talk. In 1968, the original meeting of UNCITRAL, but one of the first tasks undertaken was to ascertain whether the recently adopted ULIS and Uniform Law on Formation of Contracts would be widely accepted. When it became evident that they would not be, UNCITRAL undertook the amendment of, or the search for the amendments that would make the text generally available. And in 1980, at diplomatic conference in Vienna, the United Nations Convention on Contracts for the International Sale of Goods, known as the CISG, was adopted. The CISG has been a large success. There are now 78 countries that have adopted it. That includes, by the way, Russia, the United States, China, among them, of widely different legal systems, systems of government, and levels of economic development. Now, what made it possible for the text to achieve such wide acceptance? Well, one of them was that there was a deliberate attempt not to use words with doctrinal significance. Although the text of the CISG is different in drafting style from what is generally known in most countries, it can be read, understood, and applied by lawyers, business, arbitrators, courts, without too much trouble. Now, that it would not have been possible if, for example, the obligations of a contract of sale were dependent upon, on the one hand, consideration, or on the other, causa, which are important elements either in the common law or the civil law. Either doctrine could not have been applied in countries of the opposite. And so the avoidance of such doctrinal words and concepts was extremely important. It's also true that the CISG does not cover all issues that might arise in a contract for the sale of goods. Some of the possible issues were avoided simply because it was obvious there could be no general agreement. And it was thought that it was better to have a partial unification of the law that could be accepted than a text which attempted to have a complete unification of the law which would not have been accepted. My second example is somewhat similar, but the result has been somewhat different. That is the law of civil procedure, and as it has affected arbitration. Now, law of civil procedure, as used in the courts, exhibits the same doctrinal and procedural diversity as does the law of contracts. As a result, 40 years ago, there was nothing that could be legitimately called international commercial arbitration. Arbitration was widely practiced 40 years ago, but it was almost exclusively domestic. And it's not strange that the procedure in domestic arbitrations tended to be like the procedure in the courts of the country where the arbitration took place. Now, there was relatively little arbitration of international commercial transactions, but there was some. And that was particularly true in London. There was a great deal of arbitration in London, I'm talking 40 years ago, of international commercial transactions. But it was English arbitration, even when neither party was English. Strictly an English arbitration. Now, things began to change when UNCITRAL, arbitration rules, were adopted in 1976. They were particularly intended for use in common law, civil law arbitrations. The rules were quickly, widely adopted, and used in a number of contexts, including, starting in the late 1970s, the high-profile Iran-U.S. arbitrations taking place in The Hague, which are still going on. And they also began to be used in a number of bilateral investment treaties and are relatively widely used for investment arbitrations, those that don't take place in the International Center for the Settlement of Investment Disputes. Now, the success of the UNCITRAL arbitration rules led to the adoption of the UNCITRAL Model Law on International Commercial Arbitration in 1985, and the model law has been widely adopted and currently is the basis for the law of arbitration in all or part of 65 countries. Now, other organizations have also adopted guidelines on various aspects of international arbitration. The law is still national, and it's not identical, but there is an international standard to the conduct of arbitration that has contributed to its spectacular growth. Lawyers skilled in arbitration are able to serve as counsel and as arbitrators in proceedings around the world, which they could not do if the disputes were to be settled in the national courts. One might ask why it's been possible to come so far in the harmonization of the law of arbitration when the procedures of 40 years ago were so different. Now, in my view, the answer lies in the lead, who has taken the lead in the development. It is striking when attending a session of UNCITRAL devoted to arbitration or to go to arbitration conferences that the active speakers tend to be practitioners. They have developed an international community of practitioners of arbitration. These men and women are pragmatic. What counts is developing procedures that will allow arbitration to flourish. Very seldom are they representing a client, whether that be a commercial client or the state from which they come. They quickly learn the concerns of the lawyers from other legal systems and grow to appreciate the advantages of some of the ways that matters are handled outside their own country. The practitioners dominate the development of a harmonized law of international commercial arbitration to its advantage. Now, this brings me to my last point, which is the role of the individuals who participate in the process. And I start with a dictum that was widely used in the United States when I first began teaching half a century ago, and that is that taught law is tough law. It's hard to change. Now, what a lawyer was taught when he or she was a law student tends to mark him for the rest of his life. The student is taught not only the doctrine, but also the way that the law should be analyzed and applied. The graduate, as future lawyer, judge, business executive, government official, tends to find it difficult to break out of that way of thinking from that which he was taught. That is particularly difficult when the subject was something taught in law school. That's what makes it particularly difficult to be flexible when called upon to work on the unification of law of a subject like the law of contracts with its heavy doctrinal element. It is particularly difficult for professors of law to engage in this process, and I was one for a long time. Not only did they learn the way that the law should be analyzed as students, but they teach it. It's asking a lot of them to be teaching the national way of thinking about the law one day, and the next day to be thinking in an entirely different way. I speak from experiences of my own. We saw above that the harmonization of the law of international commercial arbitration is led by the practitioners. Unfortunately, there are very few areas of the law in which the personal commitment of the participants to the unification harmonization effort is so relatively altruistic and open to the ideas and concerns of the other participants. Now, there have been many calls for the law schools to recognize that their students will live and work in a globalized legal world. However, there is only so much that can be done. The students must be taught the law of the country where they will live and work, and consequently, that occupies the majority of their time as students. In any case, there are many practical difficulties to make the students appreciate that there are other legitimate ways to think about the law. When the attempt is made, many of the students, at least in the classroom situation, will see the digression into comparative law as a digression that has little to do with the subject at hand. They have enough to do to master the law of their own country. With all goodwill on the part of willing professors, the final result is apt to be that we turn out a new generation of law graduates that is imbued with the doctrine, means of analysis, and ethos of their own legal system. And they will be the impediments of the international harmonization and unification of the law 20 or 30 years from now. Thank you very much.
Thank you very much, Professor. Now I would like to give the floor to Mr. Eric Holder, Attorney General of the United States of America. Mr. Holder, in the course of his legal career, worked in the judicial system, in the prosecutor's offices. He practiced as a lawyer, as a private lawyer, and since 2009 he's been head of the U.S. Department of Justice. And this department plays a number of key roles in the legal and law enforcement areas, which in other countries are usually performed by a number of bodies. In particular, the Department of Justice of the U.S. administers the work of the FBI. So the significance of the Department of Justice traditionally is very high in the U.S., also because the United States encompasses 51 legal systems, 1 federal and 50 state-level systems. Mr. Holder, the floor is yours.
Thank you. It is a pleasure to be here today and to bring greetings from President Obama and the American people. And it is a privilege to join with so many distinguished leaders and essential partners from across and far beyond Russia to discuss the goals, the values, and the responsibilities that we all share. As Russia begins a new chapter in its rich and remarkable history, I want to thank the Prime Minister for welcoming me to this beautiful country and for taking part in today's discussion. Let me also thank Director Piotrovsky and Minister Konovala for their work in organizing this important forum and helping to advance the critical dialogue that so many of you started here in St. Petersburg last year. Now, since its earliest days, this city has been a center of culture and of commerce, of revolution and of innovation, of political activism and of social advancement. Today I am hopeful, and I'm also confident, that St. Petersburg will serve as a meeting ground for thoughtful, respectful discussion, and that this gathering will be a starting point for a new level of international cooperation. In times like these, times of urgent threats, of ongoing war, and uncommon legal challenges, such cooperation is essential. And I'm grateful that during my tenure as Attorney General over the last 3 years, I've had the opportunity to help forge and strengthen key international alliances and to work closely with many of the leaders who are here today in this room. Thanks to our colleagues and our counterparts worldwide, America's international law enforcement relationships have never been stronger. And I'm especially proud of what we have accomplished in reestablishing and reinforcing the ties that exist between the United States and Russia. Over the last 2 decades, and especially in recent years, our nations have found new ways to work together in common cause, in good faith, and with mutual respect, not only to turn the page on past divisions, but also to build a brighter, more secure future and a safer world. Our government leaders and law enforcement officials have worked together to identify and to dismantle transnational organized crime networks, illegal human trafficking rings, and global financial fraud schemes. We've made meaningful strides in combating gang violence, cybercrime, intellectual property theft, government corruption, as well as child exploitation. And as we bolstered our joint crime-fighting efforts, we've also opened new channels for communication and cooperation in upholding the rule of law and protecting essential civil rights. Now, from my vantage point, it's clear that the 21st century will be shaped by how well we build on this progress, and in a very real sense, by what happens right here in this nation. Today, Russia is not just the largest country on the planet, it is an influential player on the world stage. As a member of the United Nations Security Council, the Middle East Quartet, the P5+1, the six-party talks, the G8, the G20, and soon the World Trade Organization, Russia has assumed a prominent and a pivotal role in addressing today's most urgent and complex global challenges. And without question, Russia's security and prosperity, the health of its people, and the strength of its civil society will have a direct and a profound impact on the world's communities and on the advancement of human rights and human progress. And that's why the United States and so many partner nations are committed not only to a strong and prosperous Russia, but also to what such an achievement helps to ensure: enhanced global security, more robust and resilient global markets, and a thriving global community, one that reflects and honors the sacred and fortifying values of fairness, tolerance, inclusion, opportunity, and justice for all people, no matter who they are, no matter where they are from, no matter what they look like, and no matter how they worship. Now, I realize, of course, that this vision may be ambitious, but these goals are not beyond our reach, and achieving them depends on what we do today, on the paths forward that we establish, and on the partnerships that we forge, reaffirm, and prioritize. Now, although each of these issues will be discussed more specifically during this forum, I want to point out 2 specific areas where I believe the bonds of partnership between every country represented here today can and must be strengthened, and where America's support will continue in combating global terrorism and international crime, and in promoting good governance and the rule of law. First of all, because opportunity and prosperity cannot be realized without security, the United States will continue to direct every resource and tool at our command from diplomatic and military tactics to our courts and our intelligence capabilities to defeat the global terror network. In protecting our people and in defending our allies, we will respect the sovereignty of all nations as well as the rule of law. And we will strive to engage more nations in this very vital work. Second, we will strengthen current efforts to promote good governance and effective law enforcement, and to combat and to prevent the costs and the consequences of public corruption. This work is essential in creating the conditions for economic growth and modernization. As we've seen in nations large and small, rich and poor, young and old, when corruption takes hold, political institutions tend to lose legitimacy, threatening democratic stability as well as the rule of law. Corruption undermines the health of international markets, stifling competition and repelling foreign investment. And as we have learned, corruption is often a gateway crime, one that allows money laundering, gang violence, terrorism, and other crimes to thrive. The United States government and the Department of Justice that I am privileged to lead have long recognized corruption as a transnational problem. And I know firsthand that combating it is no easy task. More than 35 years ago, I began my legal career prosecuting public corruption cases in the Justice Department's Public Integrity Section. So I understand how difficult the struggle can be. As many countries, including both the United States and Russia, have learned, beating back corruption requires a fundamental shift in the way business leaders and public officials conduct and think of themselves, and in the way law enforcement operates. But I also know that such fundamental shifts can happen. For example, in the United States, we have made great strides in recent years, from our robust enforcement of the Foreign Corrupt Practices Act to the landmark Kleptocracy Asset Recovery Initiative, which we launched 2 years ago to target and to recover proceeds of foreign corruption that have been laundered into or through the United States. We are continually making strides in our fight against corruption at home and our efforts to help foreign countries increase their anti-corruption enforcement capacity. In fact, over the last 2 decades, in partnership with the United States Department of State and at the request of host nations, the Justice Department's Criminal Division has placed legal advisors in dozens of countries around the world, including Russia, to participate in developing and sustaining these institutions. We have seen clearly that prosecution is not the only effective way to curb global corruption, and that we must also work with business leaders to encourage, to ensure, and to enforce sound corporate governance. And above all, we have discovered and proven that meaningful, measurable progress is possible, and that we should not, and that we must not settle for anything less. In each of these areas, and in our ongoing work to promote global security and good governance, I want to point out that the United States intends to serve not as a patron, but as a partner, as a collaborator, not a monitor. I also want to reiterate something that President Obama said shortly after taking office when he visited the New Economic School in Moscow. In describing the key pillars of a successful democracy, he acknowledged that, and I quote, "By no means is America perfect, but it is our commitment to certain universal values which allows us to correct our imperfections, to improve constantly, and to grow stronger over time," unquote. For the American people and for the United States government, this commitment is stronger than ever. But the challenges that we face demand that this commitment be shared across jurisdictions, across borders, across oceans, and across areas of disagreement and division. If we remain committed, if we remain engaged, I have no doubt about our ability to transform this extraordinary moment of possibility into a new era of progress, marked by greater peace and unity, freedom and prosperity, and opportunity and justice for all. Thank you.
Thank you very much for this intervention. I would like to give the floor now to Anton Ivanov, Chairman of the Higher Court of Arbitration of the Russian Federation, a professor, a scholar, and head of the entire system of courts of arbitration, which are called in many countries commercial courts. The role of those courts is vital for the development of our economy. We very often litigate in courts of arbitration ourselves. You have the floor, Mr. Ivanov. Good afternoon, dear participants of the forum. It's a great pleasure to speak here at such a representative event. I'm thankful to the organizers for giving me such an opportunity. In my presentation, I would like to touch upon a rather delicate topic, which is usually omitted at international fora, because at international fora, people tend to mutually admire one another. I mean the topic of unjust competition between legal systems and the host problems related to it. Since judges are used to saying unpleasant things almost in every court case, in every court case, we have to say unpleasant things to someone at least. And I would like to say a few words on this delicate issue. Legal systems of different countries compete with one another. And this should not be a surprise to anyone. And the stronger the cooperation between countries, especially in the field of economy, the stronger the competition between legal systems. Such competition as such is beneficial. It is conducive to the optimal choice of legal structures in international relations. It allows us to abandon archaic elements of our domestic law. But this competition is useful only to the extent that it is carried out in good faith, without violating generally recognized principles of international law, especially the sovereignty of the countries and their equality in relations with one another. Unjust competition is harmful and should be avoided in the practice of relations between countries. The analysis of modern experience of the competition of legal system shows that in some cases we have obvious cases of abuse of law. In particular, number one, unjust regulation of the law of one country of relations that belong to the jurisdiction of another country. Unlike the previous speaker, I would like to give you as an example the responsibility of legal entities which are controlled by people involved in corruption, in accordance with the US and UK law, for example. Well, you cannot make a criminal statement from the point of view of criminal law that those people are corrupt, but their property relations are under pressure anyway. Another example is the responsibility of foreign legal law for breaking the antitrust legislation. Another example, procrastination, or rather the regulation of disputes by domestic courts or national courts, while those disputes belong to the jurisdiction of another country. Any pretext is sometimes used in order to justify the consideration of a certain case, the hearing of a certain case of a dispute in the national court. Another example, a ban on being involved in a litigation in another country. In some countries, such bans are quite common, although in the EU it is impossible internally because an appropriate decision was taken by the European Court of Justice. But outside the European Union, such practice survives, and I think it is contrary to the main and fundamental freedoms and human freedoms and rights, especially the right for justice. UNIDROIT and international, in a number of countries where international courts of arbitration are quite important for the economy, it is practically impossible to reverse their judgments in national courts. Number 5, ignoring by state immunity when hearing a case involving a state where such restrictions do not apply. Such examples are well known. It is the case of the Swiss company Noga and the German citizen Mr. Ziedelmeier, and the building where diplomats of the Russian Federation reside was arrested in relation with this case. There is another case against heard by an Italian herd which arrested the accounts of diplomatic agency, and another case is related to the library and archives of Mr. Schneerson, which is well known. In many cases, we see major violation of fundamental freedoms and human rights, especially the right to be heard in a competent court of justice. In other cases, we have infringements upon national sovereignties, and those infringements are far from harmless. Many large Russian entrepreneurs and companies have already been through such difficulties, and simple citizens were also involved. Let's remember all the cases about children, and our Russian women lose all such cases about parental rights in foreign courts, although in national courts women are likely to win such disputes. The Russian Federation has not been in the field of international legal competition field, not for a long time. We need to study foreign experience accumulated in the area, and this experience is quite broad, although not all measures of response are acceptable here. And Russia, by adopting an appropriate law, must guarantee to its citizens and legal entities protection against unjust competition on the part of legal systems of other countries. This guarantee should cover the actions of foreign countries, their bodies and entities, and also foreign citizens and entities that take advantage of the capabilities of their national legal systems. So we need to check to what extent this or that case goes beyond the jurisdiction of this or that country. I'm talking now about carrying out a parallel court hearing in Russia that would evaluate to what extent this or that case falls under the remit of another jurisdiction, and such a procedure could determine whether or not such a case should in fact be heard in Russia. The Russian applicant should have the right for some measures of imposing nature, or sanctions rather. A number of such sanctions are envisioned in the law of foreign countries, and it is confirmed by the legal practice. One of such measures would be confiscation from the party that erroneously applied to a foreign court the amount that was won in such a court.
Naturally, such a decision, such a judgment of the Russian court can only be enforced when there is some property located of the defendant in the country of jurisdiction. The next measure could be insurance to protect Russian investors who invest abroad. By paying a compensation fee, the Russian Federation could become a legitimate initiator of general political action against the country that violated the rights of the Russian investor. I'm not talking only about the notes of protest, where you actually file such notes in each particular case, which is not done universally right now, but also by Russia can introduce customs duties, trade and non-trade barriers, embargoes, and moratoria. Of course, provided that such measures are not in non-compliance with Russian law. Then we can also have the right of the reverse rights in relation to the plaintiffs, judges, and others who actually take unfair action against the Russian subjects, but also by court decision. And the assets of such persons could have been frozen in Russia and sometimes confiscated. Similar action is taken by other countries, for example, by the U.S., but rather outside the court system. But of course, such measures are quite rigid and tough. And if other countries agree not to adhere to such measures, we would also be not enforcing them. Thank you, Anton. Among the participants of the plenary session today, we have Jean-Paul Decory, the president of the International Union of Notaries, which spreads the best practices across the world. And the organization, which is led by Mr. Decory, is an example for many notaries public in terms of introducing Latin notariate in other countries. Notariate is important for the trade turnover because it provides for the security of trade and property rights. Mr. Decory, the floor is yours. Good afternoon, Mr. Prime Minister, ladies and gentlemen, ministers, Mr. Chairman of the Court, Mr. Minister, dear friends. First of all, I would like to thank the Chairman of the Government and the Minister of Justice, my colleagues, notaries of Russia, for the invitation to take part in this Second International Legal Forum, which is held in this beautiful city of St. Petersburg, which is so attractive to many people, to those with Russian soul and otherwise. I would like to share with you some thoughts about what is our International Union of Notaries, and perhaps also discuss the role of a notary who is a go-between of sorts between society and the government in the 21st century. What is law in modern society? Let me quote a French academician that law in society is the same as a grammar for language. Law shapes and develops society. Now, this definition of the role of law in society really shows to us that evolution of society has a direct effect on law. And thus, law must adapt to the changing society. Now, what are these adaptations that are required in the beginning of the 21st century for society? As you mentioned, Minister, today, the key priority is legal security. First of all, we can discuss globalization processes, and we can talk about an interaction between cultures and legal cultures, but sometimes they also compete. Another adaptation is the fact that our society and law are becoming more complex. Again, this is associated with the advance of technologies and science, and in general with the faster pace of our life, which we all experience. And the third point that I would like to pay attention to is the is the more judicial nature of our relationships. Well, some law enforcers are not happy with the fact that the legal that law is becoming more complex, and really it is less understandable by the public. And fourth, I think that it is something that I would like to call as unlegal action. I'm talking about money laundering, corruption, and financing of terrorism. Now, these four things really demonstrate to us that law must find an answer to the modern challenges and must do some things so that these challenges are not only met but also altered in the way that we need for them to be altered. And in this century, we are faced with the following challenges: the coexistence of legal systems, first of all. Second, simplification of legal systems, because they should not be really that complex. We have more litigation now, and we need to somehow provide extrajudicial mechanisms of dispute resolution, and also given some widespread corruption, we also need to provide a more sound basis for our efforts. Coexistence of legal systems. We all know that there are basically two principal legal systems: Latin or Roman or continental law and common law, which sometimes is also called Anglo-Saxon law. We all understand that each particular legal system has its own criterion and principles. We all understand that the continental law is more or less based on statutes, and common law is based on precedents. There's a certain hierarchy of evidence and proof. There are certain criminal procedures which are typical of the two systems. And each of these systems corresponds to different cultures, to different civilizations. Sometimes it is based on the geographical principle, and I can say, as the president of an international organization, that we never had examples when a legal system which is enforced from the outside would be successful. And hence, the first principle of coexistence is that we need to respect the choice of each particular country. And you, Mr. Prime Minister, mentioned that. We need to respect the choice of each particular country, because we understand that this is a legal system, a chosen legal system, which corresponds to the specifics of a given culture, of a given legal culture. The second aspect of such coexistence of legal systems is that all lawyers in that system must find a means of communication between themselves and between the two legal systems. And this, first of all, suggests that we need to provide for harmonization of legal systems, as it is being done in the European Union, as it is being done in the OHADA system in Africa, or in Mercosur in Latin America, or, for example, in the UNIDROIT system, a system which puts together lawyers from major jurisdictions. But we also need to provide for legal institutions and techniques that prove their efficiency. For example, in commercial law, we apply various Anglo-Saxon techniques, for example, the mechanisms of trust or leasing, and this is also applied in the continental law. I should also say that common law is quite often uses Latin law, Roman law mechanisms. I quite recently was at a seminar in Miami, and I described that, and I also talked about this in India, which is an Anglo-Saxon law country, but they also use some Roman law principles. So we can really use various mechanisms to ensure transparent legal procedures as far as litigation and notariate are concerned. For example, take apostille or the so-called executive form of the European Union. As part of our efforts within the International Union of Notaries, we are thinking about how to streamline and improve the apostille system for other countries, and this would really greatly simplify the procedure of accepting or rejecting such notarial mechanism. In the continental law, we have quite a lot of legislative norms and regulatory norms appearing all the time, and sometimes laws are becoming contradictory or not clearly understandable. And of course, sometimes it happens that people believe that transparent and clearly understandable law is a myth. This phenomenon of making legal texts more complicated is also true of the Anglo-Saxon system. And we do see that in this system, it is quite difficult to adopt various legal acts because they are written in a very complicated language. And this general tendency of making legal systems more complicated should be severed and stopped. Ordinary citizens simply not able to understand what the authors of various bills and laws write in the text, and this really undermines legal security for the public. And I think that this is something that the previous speakers in this plenary session were talking about. The impossibility of interpreting such legal acts really creates some favorable conditions for a higher number of cases of litigation also. And my third point about trying to de-juridicate the system is also important. Indeed, in most of the countries, we have more and more cases of litigation, and this is a process which we call de-juridictation process, really puts a burden on the courts and procrastinates the time required for litigation. Now, we probably need to offer three techniques to make some litigation extrajudicial. First, we need to really select cases that are offered for the Supreme Court to consider. Second, automation and computer technologies to provide for faster and more convenient document turnover. And third, using alternative methods of litigation. I'm talking about mediation, arbitrage, and other. Indeed, all these techniques need to be more developed today. Mediation, for instance, is a thing that should be suggested by, or should be offered by the legal system. Now, coming to my fourth point, the fourth challenge, which is combating criminal activities in the economy. Here again, we have many concerns. On April 28th, a report of the Justice Ministers of the European Union was published, which indeed made people quite astonished. The income of some criminal groups is reaching 1.6 trillion euros, which is even more than the annual budget of France. And indeed, we need to somehow take preventive measures and trace all criminal activities. And this way, and we need to act in a way that the government would be able to at least have at its disposal information about who owns what and what money was used to buy it. Our continental law has a very good trump card in this regard. Notary certified act. Notary public certifies a certain document on behalf of the state, and this prevents such an act to be transferred to another person. Unlike having a simple signature under a deed or under an act, and using this mechanism, we can actually trace the transaction up to the bank account, which was used to pay out money. And this way, we can also control crime. And we now understand that the continental law is effective in this regard. Now, in those countries where notary certified documents are not used, the countries where international organizations believe there is very little room to combat and count economic crimes. In the Anglo-Saxon system, there is a notion of trust, which actually prevents us to establish the true beneficiary of certain property. And in this system, it would be more difficult to counter such abuse of trust. In conclusion, let me say, my dear colleagues, that to be able to find an answer to all those concerns and challenges that I was talking about, in order to fulfill the task that we set ourselves, in order to have a balanced and modern system, we need to remember about four factors. First, this is political will. A political will that must be expressed clearly. The second factor is constructive and smart cooperation between international lawyers. And I would like to stress again my gratitude to the organizers of this International Legal Forum, because indeed such a forum really provided a vehicle for the cooperation of lawyers. And the third factor, which is very important, is the respect to traditions, cultures, habits in various countries. Law must correspond to the history and traditions of each particular country. And the fourth factor, which is universally applicable, is the role of lawyers as intermediaries between the government and the public, and they really need to fulfill their task of making law more simple. Law is humanitarian science. It's a discipline which should face the individual, and we really need to achieve that people are happy with what they receive. I would like to give the floor to Mr. Kenneth Clarke, the Lord Chancellor of Great Britain. He came to head this ministry in 2010. Before that, he was a Home Secretary and Minister and Secretary of Education, etc. We all know that the English legal system is based on different old statutes, but we also know that English law is a very modern one, which is widely used by many countries. The English law has become the basic legislation for many countries, and currently the British law is being widely used to shape the European Union law. Well, I mean, I was talking about legal cultures. A few years ago in Britain, they adopted a very good law which provides for good protection of international exhibitions held in Great Britain, and the Ministry of Justice took a very active role in adopting this law, as well as in other legal efforts. Please.
Mr. Chairman, thank you very much for that introduction. I can assure you that the precious exhibits of your museum will be safe on loan in British museums and protected by the law. And Prime Minister, ladies and gentlemen, it's an honour to be here at this very distinguished gathering discussing new challenges for the law. It's always a pleasure to be in St. Petersburg, which I first visited many years ago when I was a minister in another department when it was known as Leningrad. It was a very beautiful city then, but it was very drab and it was dilapidated and it was run down. And so it's a real pleasure to see not just the joys of the city, but the new dynamism, the new prosperity of a renewed Russia. And I trust that the friends of Russia will help to join with the Russians to be going down the path to prosperity for us all. We arrive here against a background of enormous difficulties for all of us. We're all living in the Western world, certainly, through the worst financial crisis in our living memory. The world is not short of political problems and turmoil of various kinds, with the Middle East spring taking us who knows where. And what we all have to consider is how far justice and the rule of law to which we're committed can contribute to the common good and the solution of our problems. And I'd like to begin by the role of the rule of law in helping us develop our commerce and our trade and recover from our economic difficulties. We have strong links, growing links, in trade with the Russian Federation. Governments of Russia and Britain don't always see eye to eye on everything, and it's right to acknowledge genuine differences. The peoples of Russia and Britain have a long-standing affinity reflected in the immensely strong commercial links between our nations. I'm glad to say the United Kingdom is consistently the largest foreign direct investor in Russia, with cumulative investments now of almost £30 billion. Russian firms account for 1 in 8 of all international initial public offerings on the London Stock Exchange. They raise capital, and the Russian firms comply with our strict rules of corporate governance. Business between our two countries has been growing impressively, with exports up 40% in the last year alone. And the links between us in legal services are especially strong and contributing to the development of both our economies. You yourself mentioned, Mr. Chairman, London as a leading legal and financial centre, and certainly we're proud, probably, to have one of the largest concentrations of judicial expertise in the world and the widest range of legal services. We long ago opened up our profession. More than 200 foreign law firms have offices in London. More than half of the world's leading firms headquarter themselves in the United Kingdom's capital city. And we've lately made a step change in our offer, as it were, of dealing with commercial disputes, financial, commercial and property litigation in Britain by opening a splendid new building, state-of-the-art business court with 50 judges and 31 courtrooms. It's already becoming the location of choice, we believe, for global dispute resolution. As you quite rightly say, it's not for the British to rely on the history of their legal tradition. It's the modernisation of British legal services in a global economy upon which from which I hope we're all going to benefit. Our litigation is internationally focused. In half the cases heard by the commercial court in its new headquarters, all the parties are from outside the United Kingdom. And it's not just a centre of litigation, it's designed for dispute resolution as more widely understood. More international and commercial arbitrations take place in London under English law than in any other city in the world. So, let me say clearly, we're open for business, and of course we want to work with you, competing to be lawyers and financial advisors in our new economy. We also acknowledge, someone's mentioned already, the use of English common law for contracts. And I believe it's unique among legal systems in offering the perfect combination of predictability and flexibility, backed by courts that carry a global guarantee of independence, integrity, and enforceability. But all this goes beyond, not just by pride in describing the business of London, because the point is not just one of attracting legal business to London. It's actually about the way, in our new economy, in all our countries, we should promote open legal services that actually work to the mutual benefit of all trading nations in developing the growth of investment in trade. We all benefit. It works both ways. Let me just give the examples of Moscow, St. Petersburg. 14 of our UK-based firms have an office or an affiliate office in Moscow or St. Petersburg. It's good news for Russia, not just for Britain. International legal services and regimes are the oil that keep the engine of modern commerce going. And in this country, whether it's helping to drive the emergence of Moscow as a global financial centre, which is happening, structuring the big contracts for the new St. Petersburg airport and Ring Road, its specialist legal skills, international legal skills, and the choice of different jurisdictions which are helping industry to grow and to develop. And in all our countries, that provides thousands of jobs, improving the careers of countless professionals who contribute to this country's legal base. So, I turn to the question of national regulatory frameworks, and I listened with interest to the speech about unfair international competition between jurisdictions. And of course, competition will be fair, but I'm afraid I regard competition as a benefit to us all, and retreat to parochialism at a time of global international crisis may not be the right way to go. So I hope people will resist the siren call of protectionism. And if contracts laws are being placed in the laws of other jurisdictions, the answer is to address the failings of one's own law of contract, which makes it less attractive. And if disputes are being settled in other jurisdictions, one should address the problem of the trustworthiness and the reliability of one's system of litigation and one's courts. The law exists as a servant of the citizen, not of the lawyer. The purpose of the rule of law is to provide the best, the most trustworthy way of resolving disputes and enforcing obligations. That has to be done quickly, at reasonable cost, and in a way which is trustworthy and impeccably reliable for its objectivity and its force. So Sheltering services from competition in today's economy would come at a price for the industry in all our countries and for the wider global economy. We need more trade, we need more business, we need to regulate our legal services, but sensible regulations required that supports the supply and the quality of first-class legal services to our businessmen and to our investors. They're the priorities for real investment, real modernisation. But the prosperity can't come from trade missions alone and growth in legal services. We also need to reform the justice system in all our countries and ensure that business and society as a whole can rely on something fundamentally important to the prospects of ordinary citizens and to any free market economy. That is the genuine rule of law. Across the globe, the waste, risk, and uncertainty caused by inadequate justice systems are, I believe, retarding growth in a way that the world can increasingly ill afford. Commerce and investment requires predictability and trust. Investment will only flow competitively if there's confidence that contracts will be enforced fairly and that assets are protected, that courts are impartial and run by an independent judiciary free from political or economic influence, that cases can be resolved quickly and at reasonable cost. Economists at the World Bank talk about a 300% dividend. That is, in the long run, income per head improves by roughly 300% if a country improves its governance by one standard deviation. The effect derives partly from stronger property rights, paving the way for investment, but it's also the result of freeing people to make the most of their potential by protecting their human rights, freedom of expression, freedom of assembly, freedom from unfair trial, and so on. Unhindered by fear, our citizens do things that make them and their countries richer. So progress on the rule of law is a fundamentally important goal. It's in the interest of everyone because it's the sure path to stable, prosperous societies in the modern world. So it's not just theory, it's how to deliver the right regulatory framework and the rule of law. I know from my own experience it's not easy. I freely confess that the United Kingdom has an imperfect system and we're embarked quite a lot of reform. We have a strong commitment to respect human rights, but our courts are not especially user-friendly for the ordinary citizen in their day-to-day activities. Most British citizens fear being involved in litigation because of the time, the expense, and the difficulty of resolving it. Our courts are most freely used by the very rich and by the very poor. The ordinary citizen would welcome an improvement in procedures to deal with the day-to-day business. So we've tackled some of these problems, notably at the moment in relation to bribery and action on white-collar reform, white-collar crime. On the regulatory challenge, the United Kingdom remains committed to the open system that's led to so many different firms of different nationalities operating in London. But we've taken steps to reform our professions further, introducing, for example, alternative business structures so that lawyers can now join in partnership with accountants, financial advisors and others in single, multidisciplinary organisations and organisations that will be able to attract substantial capital investment. And on the rule of law, we have, of course, lately taken action with our partners in the Council of Europe, working in partnership with other countries, including Russia, to bring reform to the European Court in Strasbourg. The United Kingdom is a friend of that court and the obligations under the European Convention of Human Rights. Our priority has been to tackle the unacceptable backlog in cases in Strasbourg, the unacceptably long delays in getting hearing cases, and ensuring the court has the tools it needs to focus relentlessly on the most serious breaches of human rights in good time. And our other key reform, as I mentioned, is our recent renewed efforts to tackle corruption via the introduction of the Bribery Act. Now, this legislation sends a clear signal that it's unacceptable for British-based firms who might be tempted to bribe, including bribing overseas, to do so. It's our public commitment that businesses operating in Britain will be held to the highest standards globally. When we introduced the new law, I must admit to meeting a degree of opposition from businesses and others concerned that it would disadvantage the United Kingdom because these practices were engaged in by their competitors in many countries throughout the world. Now the Act's in force, businesses report that far from burdening them, it is actually proving healthy and helpful to them. The reason is that a legal system that gives companies a good reason not to pay bribes saves businesses money and protects their reputation. It also means that they can point it out with hope of redress if their competitors are not so honest. Far from driving firms away, the Act is now attracting them, delivering an ethical premium. I hope we'll now see other states follow with reform in this field. Corruption is a huge burden on the economy, and the world stands to benefit if we can make a reality of the OECD standards against it. That depends in turn on all states which haven't got legislation in place, putting such legislation in place, and where states have such legislation, properly enforcing it. And I should add, we are this week announcing plans to go further in our efforts to ensure businesses operating in Britain do so fairly by bringing forward a system originally used in the United States of deferred prosecution agreements for proceeding against commercial and financial crime. It's quite difficult to take through to full criminal liability complicated financial fraud allegations against major firms, but actually, under deferred prosecution agreements, firms suspected of wrongdoing can avoid criminal prosecution if they admit liability, pay a penalty, make reparation, and undertake a tough set of agreed actions. And this is another tool we're putting in place in our country. And if the United Kingdom is making good progress on the challenges of legal policy, regulating legal services and promoting the rule of law, this great nation of Russia, in which we're privileged to be meeting, obviously has its own challenges. The modernisation for Russia as the United Kingdom is not just about information technology or the latest nanotechnology, but the ability of citizens to enjoy their own rights. The prosperous societies that we want to live in require legislation and law enforcement that do not discriminate on the grounds of ethnicity or sexual identity, courts that do not allow institutional or political interference. These are common challenges for us all and ones where we need to share experience and promote tolerance. So the United Kingdom welcomes the commitments made by President Putin and Prime Minister Medvedev to promote judicial independence and tackle corruption. We commend the reforms that have been undertaken to date in Russia, whether via Russian legislation criminalizing foreign bribery, ratification of the OECD Convention, or the landmark step of accession to the World Trade Organization last December. These are all positive steps and provide encouragement for the friends of Russia, and we trust a sound base for further reform. And as both our nations continue on the journey of reform, the United Kingdom wants to work together in our shared national interest. We're already commercial partners, as I've explained, but the rule of law needs to extend further and deeper if our countries are to thrive. I hope we can build on existing bilateral cooperation and continue towards honest, mutually beneficial and open relations. The prize is enhanced prosperity and greater stability at home and abroad, and a boost to the world economy at a time when we all certainly need it. Thank you very much, Mr. Chairman.
And now the chairperson of the Cassation Court of the French Republic, who contributes a lot to the development of legal systems, because his Cassation Court provides for the integrity of the French legal system and the harmonization of the basic principles. The practice of the Cassation Court is very important in terms of forming the law of France. Mr. Prime Minister, Mr. Chairperson, ladies and gentlemen, on the 17th of February this year, I was privileged to open up with you, Mr. Ivanov, Mr. Advisor Yakovlev, a campaign of Russia and France within the framework of the recognition of court awards. Apart from fruitful exchange that provided for the success of this event, it was an opportunity to strengthen our old links with the country that is dear to my heart. And it was a great pleasure to accept your invitation to come to the second St. Petersburg International Forum. It's my sincere pleasure to meet this city again. It has been enchanting me for a long time. It is also an opportunity to reinforce the ties that have been created within the framework of my professional activity. It's a great honor to participate in the opening event where we have high-profile representatives of the legal community. The French legal system is very grateful to you. So, Mr. Prime Minister, ministers, let me manifest the recognition of our friendship that puts together our two nations. And on behalf of myself and on behalf of the French delegation that I'm the head of, let me congratulate you on the splendid organization of this event.
So, in the first several months of this year, we've seen a lot of turbulences, and this period turned out to be as precarious as the one before it. And, of course, our system of justice could not but take into account all these things, such as the consequences of the crisis, the impact of stronger attention to fundamental rights and freedoms, and the tasks of the system of justice has become even more significant. We need to create new tools to respond to topical challenges of the future. And although this is one of the manifestations of the framework of reference of the state, the law, the legal system, the system of justice is less and less concentrated within the boundaries of one jurisdiction, because we often hear cases related to transnational relations, and therefore we have some unified judicial space that is coming into being. We have seen the emergence of hybrid procedures on the basis of both common and civil law. The accusative nature of such litigations, well, is sometimes mixed with inquisition, but we have on the one hand Roman or continental law, on the other hand we have common law based on precedents. Those are the most influential models of justice. Those are two systems of logic that are significantly different from one another. One is based on the authority of the president, and the other is based on a number of codified regulations and requirements. Both have merits and disadvantages. In the countries of common law, the source of law is by and large those situations that occurred in the past. And this is a pragmatic system, of course, but very often this system of justice turns out to be very expensive for the society, both in terms of time and money. Continental law is clearer, it is more logical, it is more predictable. But here we deal with the fact that this system is rather abstract and remote from realities. This competition and this coexistence on the basis of competition, we have certain dilemmas that we face in Europe. We have differences in Europe between common and civil law. In other continents, we have even conflicts arising out of the competition of these legal systems. The Cassation Court that I am chair of has come to the conclusion that there cannot be a unilateral approach in the global world. This is related to the establishment of various structures and entities that are conducive both to harmonization and mutual influence. So the network of heads of Supreme Courts of the European Union countries that is based at our Cassation Court gives a special forum for European judges where they can meet and discuss and exchange opinions. Thanks to these exchanges, we can recognize a significant level of convergence of court rulings, in spite of the significant differences in the legal procedure, which is by and large rooted in history. Outside the European continent, the French language is the main tool of promoting our legal ideas, and our courts play a very important role thanks to the association of higher courts of cassation of those countries that use the French language. The Secretariat General of this organization is also based in France. Within the framework of this structure, we see difficulties of a political and cultural nature, but we need to somehow unite 50 jurisdictions that are part of this organization. They must somehow converge in order to speak in one voice and in order to better respond to globalization challenges and the informatization epoch. Our court over the past several years have been developing both bilateral cooperation with our counterparts in other countries, and on the other hand, extended services in many languages, Chinese, Arabic, Japanese, and of course Russian. We disseminated a presentation of our cassation procedure, and we also disseminated materials containing rulings, a wide number of rulings of our courts. The French Court of Cassation welcomes the strengthening of the dialogue between different legal cultures, which is the topic of our global forum organized here in St. Petersburg. Mr. Prime Minister, you understand full well that lawyers are no longer working in isolation. They belong to a certain international community, which in itself is part of a broader network. Opening our today's event, you presented the system of justice of your country, and you spoke about a very important instrument of legal and judicial modernization, which is based on the comparison of legal systems and professional practices in this sphere. So I would like to wish success in the work that has started today. And once again, I would like to say to you, Mr. Prime Minister and Mr. Ministers, well, that I'm very thankful to you on behalf of the French delegation at the Second International Legal Forum in St. Petersburg. In a globalized world, in order to discuss topics that are going to be raised during our deliberations here, and I have to say that we couldn't have possibly found a better place than this magnificent city for our meeting, which is a mixture of cultures and influences. Thank you very much. Mr. Medvedev, would you like to say something in summary of our discussion?
Even if I didn't want, I would do that, but I would like to do that. It was a long time sitting here. Esteemed colleagues, I've heard your statements with a big interest. These statements were very informative, and due to my service, I visit many fora, and I would like to say that our legal forum is a very pragmatic one, and the statements of my colleagues that I have heard here, the heads of legal institutions, the representatives of the judiciary, were very substantial. And it is very important when we are here in this hall with a lot of guests attending. It is important that we are talking about the issues, about the problems in a very sincere way, and at the same time we put forward the common agenda. I would like to share with you my own impressions of what I have heard. I am completely agreed with what Mr. Bergson said regarding to legal education. I would like to say that what we were learning during our time as students takes very deep roots in our brain, and this knowledge forms our lawyer's face, and the legal education should be susceptible to all those globalized trends that are now present in the whole world. I fully remember the transition to a new society in our country. It was very difficult to study at that time. The students asked teachers questions about very difficult matters, and the teachers had very big difficulties to answer those questions because they had different education. It was very ideologized, and this type of education is still in our hands, but I would like to admit that we have overcome that type of thinking, and now we are living in a new world. And though there is a difference between the common law and the continental Latin law, the international law becomes more and more globalized. That's why I fully support this idea, and I would like also to share that list of items that Mr. Holder proposed regarding the partnership between our two countries and between other states as well, on the very topical issues of the modern global agenda. These are global terrorism, rule of law, and in this area we have achieved great progress for the last years, in spite of the fact that our standings on some issues diverge. And the other topic for the international cooperation, where we have also achieved a quite high level of cooperation, is combating corruption. I would like to say that this is a transnational issue, and my colleagues have also spoken about that. We all understand the need to combat corruption, and we know that we should use new methods because the world is changing, and new, very fantastical ways of transferring money have emerged, and the money laundering methods have improved as well. And so we need to improve our legal systems. Here we need to move forward in the area of improving control systems. And besides that, the very important area is the habits, and corruption model is very widespread in the world. And I'm not talking only about the senior governance. I'm talking about the corruption model, which shows itself in everyday life as well, in our everyday habits. And if we are talking to prevention, talking about the prevention of corruption, this fight should be waged on all the levels of our life. And I completely agree with the words by the Minister of Justice of introduction about new corporate standards. The crisis proved that fully. We have seen many well-to-be people that were not involved in some suspicious operations, but nevertheless they deceived a lot of citizens, a lot of their clients, and it was common in all the countries. And we should understand that the transition to new standards of corporate governance is a very important task for all the states, and we are talking about that regularly during our G20 summits. I believe that lawyers can contribute to the development of this system as well. The president of the Supreme Arbitrage Court of Russia, my colleague Mr. Ivanov, was talking about the competitiveness, about good competitiveness and bad competitiveness, where he sees a negative element of today's legal life. I would like to support him as a whole, especially in the area that the inefficiency of the legal system will always be a very convincing motive to use other legal systems, to resort to the services of foreign courts or international courts. But at the same time, it should not be the ground for spreading foreign legal systems to other countries, to other citizens, because mostly not humanistic considerations support that, but a real pragmatic goals. And I think that all that have been said, including the methods of protection from non-good faith competitiveness, should be used, if only because this is just a civilized method of enhancing legal system. I think that this idea should be investigated, should be surveyed, should be researched. The embargo, the moratorium, retortion, this is very good, but sometimes it is practiced in international life, and I think that in any case it is better than military operations, and this should be aimed at protecting the interests of specific people which need legal aid, legal assistance, and need their disputes to be resolved. Mr. Decourt was talking about the complexification of the legal field, and global problems require global response. But we believe, we hope that as the legal field becomes more complex, the different forms of legal interaction will become more easy, and by the development of some IT systems. Still, we have to develop further our legal systems, because current legal systems do not contribute to the protection of the rights of our citizens and to avoid differences. Probably today we didn't fully understand that the notary service, but the countries that use notary services now can make their contributions in such issues as combating corruption, for example. And we fully understand that nobody is ideal, and Mr. Decourt himself talked about the trusts and other forms that are widely used now, including in the states of continental law, where the form of will fixation is used. And here we have shared our experiences. The presentation of the statement of Mr. Clark, of Minister of Justice of the Great Britain, was very, very interesting. It is true that Russian business is using London forum for doing their business because this forum, this platform is very well managed. The system is very well maintained, and the IPO at London Exchange is a very solid way to attract investments. I think that we will cooperate further in this area, even if we have some criticisms on some shared problems. Minister also said about the fact that there should not be any judicial competitiveness and no protectionism, but I would disagree with that, because we are not talking about the protectionism in economy, which of course is bad and which we are all combating. We all have our problems in this area, but if we talk about the law still has some national boundaries and national legal systems that are not diffused in the world, and any state will nonetheless patronage its own legal system, despite the successes of integration. The topic of human rights protection is a very delicate one and is very interesting, given the complex processes that are underway in the modern world, in our country, in Europe, and in Arab East. This is the task for a judicial system, this is the task of creating a rule of law, and here we have to use the common models of behavior towards the situations that emerge anywhere from New York to London to Moscow. We have to change ourselves. We should not just rigidify our sanctions, our responsibility, or just switch off Twitter during civil uprisings. On the whole, esteemed colleagues, it was very interesting for me to listen to your statements, especially Mr. Lamanda and Mr. Wu from the Republic of China. I would like to say that as a result of our interaction, we have come to a better understanding of our realities, and what is more important, we are formulating the future agenda. Lawyers seem to be formal people, and probably they conduct some legal or economic processes, but we here in this hall understand how valuable is our opinion, how valuable is our standing, which is which is a reflection of somebody's will, and sometimes it even predicts our policies, predicts the development of economy, and creates the foundation for the prosperity of the people. I'm very grateful for those of you who came today to St. Petersburg. I wish you a very interesting deliberations during your sections, and I hope we will meet again in such a beautiful city and in such a beautiful season as spring is. Thank you very much.
Thank you very much. This concludes the plenary session, and I would like to invite all the participants to have lunch.